Judge, on this case, I filed a motion for entry of judgment, Your Honor. We just need to get an order signed, Judge. We've already had a trial on it. I presented evidence. I submitted 2 proposed orders. Mr. Kane, Judge, all the times he's been coming, he's never filed one answer. At least I've never seen one. I've never been served with anything from him. So at this point, Judge, I'm just entitled to judgment as a matter of law. He hasn't filed anything. He's never filed any pleadings. And so we've had a hearing on this. I submitted 2 proposed orders. The first one is just to make the temporary orders final and just bring finality to this case. And the second order I submitted was one where I believe that Mr. King was making in excess of the guidelines, which would make his child support $1,610 according to my calculations. And the other one was just to make the temporary orders final at $880, Judge. So we just wanted to see if you would just sign one or the other and just bring finality to the case, Judge.
Let me get a response from Mr. Kane, and then I have questions for each. Mr. Kane, response?
I did submit documentation and the Thomas Reuter stuff.
Right out of the gate, the attorney steps in asking the judge to simply sign an order and wrap the case up. His argument is straightforward. The father never filed an official answer, never submitted pleadings, and according to him, that silence should legally hand them the judgment. But the twist here is that 2 completely different outcomes are being offered. Either finalize the temporary support at $880 or jump it all the way to $1,610. The lawyer is essentially saying the court already has enough to choose. So why delay the decision any longer?
That's where I was told to submit anything.
All right. So these are the questions I have. I'll ask Mr. Cantu first, and then I'll follow up with the questions for Mr. Kane. Mr. Cantu, the court recalls multiple hearings and a lot of information.
Yes, sir.
This case wasn't straightforward, right? I mean, usually 99 times out of 100, people submit their black and white financial information, and the court assesses child support based on the calculation as required by law. In this situation, Mr. Kane's finances aren't as clear-cut as in many other cases. So the parties agreed to submit documentation that allowed the court to assess what the correct calculation of child support should be, if any should be modified. In that interim, or I should say thereafter, the parties did file information. The court received, reviewed, and considered all of that information, and then the court issued an order requesting additional information.
The judge slows everything down and reminds the courtroom that this case isn't as simple as most child support disputes. Normally, parents submit clear financial records and the math does the rest. But here, the father's finances appear messy and difficult to interpret. The judge points out that both sides were asked to submit documentation so the court could properly calculate support. Instead of rushing into a ruling, the judge is signaling something important. Before any order is signed, the financial picture must actually make sense.
I guess let me ask this question to both, and then we'll take it from there. Based on that court order, Mr. Cantu, what information was provided that allows the court to make that assessment?
Judge, to respond to that, Judge, because the discovery period had closed, I was no longer able to obtain any other information from Mr. King. He did provide to me all the information that we produced at trial, as far as tax returns, everything that he provided, bank statements that I submitted into evidence, was what the court at the beginning had based its temporary ruling to make to increase the child support. After we had the trial and I submitted everything that I could, I no longer was able to get anything other than what I submitted as evidence there. So the discovery period had closed. I couldn't serve with anything anymore. So I just wasn't able to get anything else for you, Judge.
Well, and that's a perfectly valid and honest answer, and I certainly appreciate that. So then, before I follow up with that, let me get Mr. Kane's response. And I think I sent the order to both Mr. Kane. The information.
The focus turns to a critical question. Did anyone actually provide the information the judge asked for? The attorney admits something surprising. Discovery had already closed, meaning he couldn't request additional financial documents anymore. So he's relying only on the tax returns and bank statements already presented at trial. In other words, the case may now depend entirely on old evidence. That's a risky position in court, because when discovery closes, whatever you have on the record is all the judge can truly rely on.
Information requested by the court, was that information provided to the court?
Yes, sir.
All right. And my follow-up question then, Mr. Cantu, then based on the information that you submitted and based on the information, evidence, and testimony provided to the court, what is Ms. Medellin's request, your client's request, and how is it supported by the information in the record?
The judge pivots to the heart of the matter. What exactly is the mother asking for, and what evidence supports it? Courts don't just guess at child support numbers. They require a clear connection between financial proof and the requested amount. The judge is basically challenging the attorney to show the math and the legal justification. It's a subtle but powerful moment where the court signals that arguments alone won't cut it. The numbers must actually stand on the evidence in the record.
So, again, he hasn't, I understand what he's saying, that he might have, I guess, produced it. I don't even know how he did it because I wasn't served with anything he produced. What I will respond to the court is I'll say, look, Judge, based on what I have to work with, the court did make the finding that there was enough there to at least raise the child support to $880. It was $500 and something. The court raised it to $880, which we're okay with that. However, on trial, when it came to trial, we were here for about 6 hours. Based on what I presented, based on just one withdrawal that Mr. King made, which was in the evidence, which showed there was one withdrawal that he made, which converted into income of $450,000. He has the potential and earning capacity where that would put him over the guidelines, and then that would put his child support, according to what I have, at $1,610 a month. We would ask that the court, based on what we've submitted, what was presented at that trial.
The accusation gets dramatic. The attorney claims the father made a withdrawal that effectively shows income of $450,000. If that number is treated as income, the child support calculation jumps dramatically to $1,610 per month. But the attorney also hedges his bet. If the court isn't convinced, then at least keep the support at $880. This is classic legal strategy. Present the high number as justified, but keep a safer backup option ready so the court still rules in your favor.
Increase it to that amount. If the court does not believe it can, then I would just request that based on the findings the court made at the temporary order hearing, just to make that order final and leave it at 880. I submitted 2 proposed orders, and the court can sign one or the other. And so,
and that was the court's final question. The difference between the first proposed and the second proposed order is
one order is at 1610 and the other is at 880.
Oh, I understand.
Yes, sir.
Mr. Kane, court yields the floor to you. What response, if any, would you like to make?
So
the courtroom tension builds as the judge turns directly to the father for his response. After hearing a major financial accusation, the floor finally shifts to the man whose finances are being questioned. This moment matters because child support decisions hinge heavily on credibility. When a judge hears both sides directly, they're not just evaluating documents. They're watching how each person explains their financial reality and whether the explanation actually lines up with the evidence.
Mr. Cantu said that the $450,000 was income, and it wasn't, and I submitted the documentation showing that that $450,000 went from one bank to another bank to pay payroll that we had at the time, and then we lost that job, and went into bankruptcy and still going through that as well. But I submitted that documentation showing that. I submitted too on the calculations. I'm so far behind on everything now. Everything I get, we had a company that we did government contracts. So anything I get is going to them because of losing that job and going through the bankruptcy. I'm actually going through a divorce as well, and I submitted all that documentation for this hearing.
You're going to...
The father pushes back hard on that $450,000 claim. According to him, it wasn't income at all. It was simply money transferred between bank accounts to cover company payroll. He explains that the business later lost a government contract and ultimately collapsed into bankruptcy. That changes the entire narrative. Instead of a wealthy parent hiding income, he paints the picture of a failed business and massive financial pressure. In child support cases, that distinction between income and business transfers can completely change the calculation.
Through a divorce and you submitted that documentation?
Correct.
How would that be relevant to this proceeding?
Because I've got child support that they temporarily ordered, which is what you had done based on Mr. Cantu's statements and mine. You said temporarily we would set it at $880.
Right.
And we submitted the rest of the documentation supporting, I guess you would say, my side versus his side of what child support should be set at.
So respond to Mr. Cantu. Mr. Cantu says to the court that the court has sufficient information evidence in the record to set child support based on those transfers at $1,610. He says, and even if the court doesn't deem that as income, that there is sufficient information to set it at $880. Please respond to that.
There's not.
As the judge tries to cut through the confusion, the court presses the father to directly address the attorney's argument. Even if the $450,000 isn't income, why shouldn't support still be set at $880? Judges often do this when both sides are talking past each other. The court is trying to simplify the dispute into a clear question. What does the evidence actually prove the father can afford to pay each month?
I submitted all my tax returns and all of my bank statements. Mr. Cantu's saying that the $450,000 transfer is the justification for the 1610, and it's not, because it's not income. That $450,000 was transferred from one bank to another bank to pay out. And I submitted that as well in bank statements. And I've submitted all my tax returns, and we're showing a loss. Mr. Cantu said, well, how are you living if you're not making any money? I said then and sent the documentation in on loans.
Well, I understand that, but to his point, let me see if I can try to quickly, I'm trying to get an answer to give you a fair shot at this hearing. His statement to the court is, the court has and should set child support at $1,600, but even if Mr. Kane is right and that isn't income under the law, then child support should at least at the minimum be set at $880. What is your response to that? And as a follow-up, if you disagree with that, what then do you believe the evidence shows child support should be set at?
The father doubles down on his defense. He says all tax returns and bank statements were submitted and they show losses, not profits. He also explains that he's surviving on loans, not income, after the business collapse. This is a critical legal point. Child support is generally calculated from income, not borrowed money. If the court believes his finances truly show losses and debt, that could significantly weaken the argument for raising his payment to the higher amount.
So the $880 is what you had actually done a calculation on based on Mr. Cantu saying that I had the potential to make an income to increase the child support. pretty much where I submitted saying that, I'm doing everything I can now and can't pay it. And if that's the case, because I don't have any income that I keep, so to speak, minimum wage, I honestly can't even afford that.
The judge asks perhaps the most practical question of the hearing. If the current numbers are wrong, what amount should child support actually be? Instead of giving a precise figure, the father argues that his income is basically equivalent to minimum wage and that he can barely manage even the $880 already ordered temporarily. That response highlights the core conflict in many support cases, one parent demanding accountability, while the other claims financial survival is already a struggle.
Final question, Mr. Kane. You said you were going through a divorce. In what state is that?
Wisconsin.
Now, as part of that family law proceeding or any other family law proceeding, are you responsible for the payment of child support to any other person other than the child in this case?
Yes, sir.
How many?
One.
So one child here and one child in the Wisconsin court?
Correct.
And in the Wisconsin court, and this isn't binding on the court, I'm just trying to get a picture of what is going on. In the Wisconsin court, are you ordered to pay child support?
Yes, sir. It's a temporary order.
Might find themselves in the same position we're in. So in that temporary order, what amount, if any, are you ordered to pay in child support?
That was set at, and I submitted that. I think it's $760 on temporary orders. And I don't have an attorney in this one either. They based that on the last year that we showed a profit, I guess you could say.
Well, and like I said, that whatever happens over there isn't binding on this court, other than the application of Texas law that says that you should get some credit. In other words, if you have a child here and one in this court, one in that court, but you start to see a pattern, Mr. Kane, about how the law universally applies everywhere and how the rules of evidence and the standards set tend to flow in the same direction. It sounds like the orders of this court, at least on a temporary basis, are pretty consistent, if not similar, with the Wisconsin court. What I'm trying to gauge is whether we are so far off, too high or too low, and it sounds like, based on the evidence that you submit, courts tend to reach very similar outcomes.
The court
I tell you what, I'm going to take this.
The situation becomes even more complicated. The judge learns that the father is also involved in another child support case in Wisconsin for a different child, where he's already ordered to pay about $760 per month. Suddenly, the court is looking at multiple obligations across state lines. The judge explains that courts often end up reaching similar support numbers even in different states, because the legal principles and financial calculations follow similar patterns everywhere.
Mr. Cantu and Mr. Kane, as a kind of, and I'll construe this not only as a motion to enter, but I will reconsider to review and reevaluate based on Mr. Cantu's request to set, based on the evidence and testimony, at $1,610, and in the alternative to be consistent with the court's previous finding at $880, and then I will temper that with Mr. Kane's request to set at minimum wage, and I will take into account all of the evidence testimony submitted to the court, and I will sign off on one of the orders. And if the findings of the court are different from the child support calculation in one of the orders, I'll scratch it out and write it in. Mr. Kane, is there any other information, evidence, and testimony that the court should take into consideration?
I don't have any documentation. Our next court here in Wisconsin is mid-May,
Sure.
and at that point, the 880 was temporary orders until the final hearing.
Shows the judge stepping back to reconsider everything. Instead of rushing into a ruling, the court decides to review all the evidence again and will sign an order by March 30th. The judge also hints that the $880 amount might already be close to what the law supports, especially considering the second child support obligation. Meanwhile, the mother speaks up about nearly $25,000 in unpaid support, showing the real-world impact behind the legal arguments. It's a reminder that while courts analyze numbers and documents, families are living with the consequences every day.